clear.
Okay, let's go on the record on cause number DC 1917403, James E. Davis versus BNSF Railway Company. Counsel, make your appearances.
Your Honor, Jason Smith for the plaintiff.
And Brian Neal for the defendant, and also with me is Catherine Barbary.
Great, okay. So this is a motion to transfer venue. Oh, I'm sorry, was there anyone else here? Did I interrupt?
Say Walt Taylor also here for the plaintiff, Your Honor. Sorry, I had myself muted.
That's okay. I've already read the briefing on this. This is a motion to transfer venue, if I recall correctly, and it involves is Dallas County a venue, a county of proper venue based on the plaintiff receiving correspondence essentially in phone calls in Dallas County. Is that right?
Yes.
And letters, Your Honor. That's right.
What'd you say?
And letters, Your Honor. That's right.
Correspondence, yeah, correspondence and phone calls. And so there were a number of cases cited here that discussed specifically, I guess, fraud cases where there were phone calls and things like that made. The defendant, I think, tried to distinguish those, saying that those were employment law cases. But I didn't see that. Are there any employment law cases on point that discuss this issue, I guess?
Judge, the only cases I would say that are on point would be those federal cases that we've cited. And I normally wouldn't come in and cite federal cases on a state venue issue, but that's the reason I did, is that neither of us has an employment case on point or really an employment case at all on this issue. And, the federal cases say that when we're talking about employment that's happening in one location, the receipt of a phone call that has something to do with the claim isn't sufficient in the county of suit. And, if you look at the elements of the claim, you've got to have employment, and that was entirely in Tarrant County. You've got to have discriminatory intent. That was allegedly entirely in Tarrant County. Then you've got the adverse action, and that's the one where we're really arguing about, I think. I'd say that's part in Dallas and part in Tarrant. So to me, what we've got is basically something that in the pre-1995 statute probably would have been good enough, because there all you had to have was a part, not a substantial part of the claim in the county of suit. And you'd look to where it accrued and not where the events occurred. So our position is basically that in an employment case where somebody lives in one county, works in another, and the only connection to the defendant's actions, from the defendant's actions to that plaintiff, is that the defendant, rather than make the person drive over to the other county just to be told his employment was terminated, calls him on the phone and tells him. And there's no rhyme, there's no magic here that he happened to be at home when they called him. So if we have a rule that wherever the defendant makes a phone call to advise an employee of an adverse action is a place of venue, then he could have been on vacation in Galveston and gotten a call on his cell phone. He could have been driving to and from that vacation in Galveston. And I don't think it's a good rule for anybody to say that wherever by happenstance the employer happened to get him to advise him of the adverse action that was clearly a decision made in another county is proper venue when the statutory standard is substantial part of the events occurring, rather than just like it used to be a part of the events occurring. So that's our basic argument, Judge, and I hope I answered your question in the beginning about, the fact is neither one of us has a case on point, and I'd say that the cases they cited, besides not being employment cases, there were many elements of the claim that were connected to the county of suit in those cases. You had the KW construction case, it was a breach of contract claim. The contract was formed over the phone between the parties, and the contract required payment in the county of suit. So you've got formation and breach both occurring in the county of suit versus here. So you've got one half of one element that is in Dallas County. So we think the proper rule is proper outcome here is you ought to move it to Tarrant County. And I say that being a Dallas resident and a Dallas lawyer myself, I'm making it slightly harder on myself to go to Tarrant County, but I think that's got to be what the right rule is in an employment case.
Okay.
Um,
Response?
Your Honor, just briefly, first, it really doesn't hang on the happenstance of where the plaintiff is because when the phone call's made, because in addition to the phone call, they mailed 2 letters to his home. So they did choose to communicate with him in Dallas rather than calling him and say, come in, we need to talk to you. And so first of all, if BNSF wants to venue shop here, all they have to do is call the employees into wherever it is they work and terminate them there in person. They chose not to do that. Second of all, it's not a quantitative analysis. In other words, you don't count the number of elements, and add them up. It's not an election, or a contest. It's a qualitative analysis. And it's hard to imagine any element of an employment claim, whether it's discrimination or retaliation, that is more substantial than the adverse employment action, or here, the termination. And then you go straight to the, let me find it here, Your Honor, the first case that we cited, which is the Texas Specialty Trailers Inc. case. And you say, okay, what if the shoe was on the other foot and everything that happened in Tarrant County had actually happened in Dallas County, and everything that actually happened in Dallas County had happened in Tarrant County? What would the Fort Worth Court of Appeals do? And so you look at the Texas Specialty Trailers Inc. case, and there you got receipt of phone calls and letters in a particular county that are facts that weigh in favor of finding venue. And then if you skip down to the, I think it's the shareholder case, the stockholder petition case, Massey versus Columbus State Bank. Now, admittedly, the defendants there had waived venue, but the court does comment on it and says, look, venue is proper in Colorado County because the events giving rise to this lawsuit were the threatening and harassing phone calls and letters sent to the bank in Colorado County. So, the court says the telephone calls and the letters going to that county make it a county of proper venue. So I think if you also look at the rulings or holdings in those cases, with the exception of Massey, because it's the one where the defendant waived venue in the trial court, in all the other cases, if the trial court transferred venue, it got reversed. And if it denied the transfer of venue, it got affirmed. So I don't really think you need to go to the federal cases. I think the Texas analysis is sufficient.
Those aren't employment law cases, correct?
None of the cases on either side, state or federal, are employment law cases, as I understand.
Okay.
Well, just on that last point, the federal cases we cited, I think all of them we've attached included in the notebook are employment cases, except for the first one. But they are federal employment cases, and it is maybe more helpful than it normally would be to look to federal cases here, because when the Texas legislature amended the statute in 1995 and made venue more specific and requiring substantial contact, it copied the federal language, and so that's why.
So the cases that are cited by the plaintiffs in this case, are they before or after the amendment about adding substantial?
I think that they are. I know most of them and maybe all of them are after.
That's right.
So we're not arguing
after, or did you say after?
After, that's right. And we're not arguing that those cases are wrong. We're just saying that those cases involved a lot more contact and more substantial contact with the county of suit that we have here. Just a minute on that Texas Specialty Trailers case, the memorandum opinion from 2009 Fort Worth Court of Appeals. It's basically the same as the KW construction case. There were multiple contacts back and forth with the county of suit and the other county, and it was a DTPA misrepresentation claim, and the misrepresentation itself, as well as the formation of the contract at issue and the plaintiff's reliance, all occurred. The first two occurred on the phone call into the county of suit, and then the reliance, of course, was where the plaintiff was. So in none of those cases do you have this entire set of elements, this entire relationship that is in one county and one thing, and that's notification of the plaintiff in the county of suit. And I say one thing, even though there was a phone call and then there was a follow-up letter, then he asked him to reconsider, and there was a letter saying no, which I think you could probably set aside because all it did was confirm the original decision, and that's not really part of the cause of action anyway. But all you have is one thing repeated 2 or, depending on how you look at it, 3 times, that your employment is terminated. And that's the only contact whatsoever with Dallas County. You know, he didn't even apply for the job from Dallas County. He started working in Oklahoma and moved from Oklahoma to Tarrant County for the work. So it's not even one where you could say the employment contract was formed between the 2 counties. And I just think that I just don't see how we could possibly say that is a, you know, quote, substantial part of the events giving rise to the cause of action.
I'm sorry, Arthur, could I address that new point?
Sure.
So if this were let's say, a wage claim, we would be talking about the fact that the entire time that he worked for BNSF, he lived in Dallas County, and that his wages were deposited, you know, in his bank account, which he then accessed in Dallas County, and we'd be talking about the place where payment was made. That's not the claim that we've brought. The claim that we've brought is a discrimination and retaliation claim, where it is the adverse employment action. And what the cases that I've given you, Your Honor, all of which I believe are after the 1995 amendment, and in particular, the Fort Worth case, I know for sure is after that amendment. They all say that a phone call takes place in both counties, and the letters take place in the county in which they were received. So again, I don't think it's a quantitative analysis. I think it's a qualitative analysis, and it's hard to imagine a more substantial part of an employment case than the adverse employment action, which here is termination.
Judge, can I make
Mr.
one?
Taylor, I guess my concern is that is this. I think this is kind of a close call, but if we're wrong, let's say I agree with you and we're wrong, and we go all the way through trial, and you win millions of dollars, then couldn't we get reversed if we're wrong about this?
Go ahead, Jason.
Your Honor, could I speak to that? As the board certified appellate lawyer, I'll probably handle the appeal. One, I don't think we would be wrong, because we have case law that says a substantial portion of a cause of action can be a phone call or a letter. But I think if I could also address that, they argued that the accrual is what you look at. The Texas Supreme Court has said in an employment case, it accrues at the time of termination. And the termination was in Dallas County. You're right. I mean, they could, just as with any motion to transfer venue, if it's reversed by the Court of Appeals, it could be, remanded for a new trial. But I think the Fort Worth Court of Appeals, where this would be ending up, has spoken and said that a phone call and a letter are sufficient. So I understand your question, but I don't want to deprive our client of a correct venue just because BNSF didn't call him over to Tarrant County. And I love Tarrant County. I grew up here. But I don't want them to, just because they didn't bring him in to where they're located and terminate him. I think there are consequences for that, as shown by the Texas specialty case.
I just want to make this comment. I'm sorry, I didn't interrupt you, Mr. Neal.
Could I respond just very briefly? One reason is I want to be clear. I'm not arguing. When I mentioned the accrual earlier, that's under the old statute. The old statute said the venue lies where a part of the claim accrues, and the current statute is where all or substantial part of the events occurred. So when I mentioned accrual, that was under the old statute. That's not what we're arguing now. And then to just follow up on your question to opposing counsel, and as the also board certified appellate attorney who would be handling the appeal, I'll say the difference here in the choices is that if venue is improper, there is no harmless error rule for venue. If venue is improper, it's automatically reversible error. Versus if you go to the Fort Worth court, as far as I know, they'd have to show harmful error, and I don't know how they could possibly do that since we agree that venue is proper. I know that there's an older Supreme Court case that raises a question about that, but that's under the old statute.
That, Your Honor, if I could, that's an incorrect statement. It is incorrect to say that we wouldn't have the same appellate issue to Fort Worth. It's still if it's wrong, then it would have to be transferred back to Dallas. And that's the Jaska case out of the Dallas Court of Appeals that I handled, where the Dallas Court of Appeals said that if you transfer the venue and the venue's wrong, then you transfer it back to where it should have been. So I think it's both sides of the coin, Your Honor. That if we could have the same problem, and we've got binding precedent in Fort Worth with that Fort Worth Court of Appeals case.
Not
So
to mention,
explain, I guess, why should I be following Fort Worth instead of the Dallas Court of Appeals?
Well,
I guess if I transfer it to Fort Worth, then they would make the decision. Is that what you're saying?
That's what I'm saying, Your Honor. The other thing that I would say is that if they had not terminated our client, we wouldn't be here. There wouldn't be a lawsuit. So I would argue it is the operative fact that gave rise to our client's claim, is the fact that he was fired, and he was fired by phone and by letter in Dallas County.
All right. I'm going to
go ahead, Your Honor.
A motion to transfer. You guys submit an order for me.
I'm sorry, Your Honor, I missed the ruling. I don't know why.
I'm going to deny the motion to transfer venue. Have you submitted an order for me?
We will, Your Honor, and we'll circulate it to Mr. Neal to approve as to form.
Okay, try to get that to me by tomorrow, and
Sure.
email my court coordinator as well as e-file it.
We will, Your Honor.
Will do. Thank you, Your Honor.
All right, thank you guys. You guys be safe, okay?
Yes,
Thanks.
it would be
Stay well.
excused.
May. Bye-bye. Okay, I think we have a motion for continuance that's set. Mr. Trong, are you here for the motion for continuance?
I am, Your Honor.
And so am I, Your Honor. Javier Gonzalez for plaintiff.
Oh, Mr. Javier. Let's see. This is Hulbert versus Eagle Systems. Is that right?
Correct.
Yes, Your Honor.
All right, let's take care. The other one's going to be a lot longer, so let's go ahead and take care of this one now. Kind of tell me what's going on here.
Gordon, would you like me to go, or it's agreed? So I think either of us could explain to the court why we're here.
You can go.
Your Honor, and please court, we're here because we've done a lot of work on the case since the last time we were in front of the court. I believe we've taken upwards of 5 or 6 fact witness depositions. We've had a motion for summary judgment in front of the court. I believe we've been diligent in trying to get the case ready. A couple of factors that were included in the agreed motion for continuance. We are still trying to schedule expert depositions, and we are still needing to mediate the case. The case has been on file for less than 1 year when we filed our agreed motion for continuance. And then lastly, Your Honor, with the December 1st of this year trial setting, my client, Jean Holbert, the sister of the deceased, actually does live out of state, and she is 68 years old. I would, of course, want her to appear in person for trial. However, this was not included in the agreed motion, but I don't think Mr. Trong would be opposed to me stating this for Your Honor. I would like to wait a little while so that when she does have to travel, from her home in New Mexico, it's safer and given her age, I don't want to have to ask her to do that in the next few weeks on top of everything else.
Okay. All
I don't know.
right. When do you want me to reset it?
Gordon, we had talked about,
I think we just we agreed to about to at least 120 days just to kind of cover base with the mediators, their scheduling and our expert witness depositions. So I would say after June.
I would tend to agree, Your Honor.
Well, 120 days would be more like April, right? From
Right,
December.
I think you meant 180 days, Your Honor.
Well, it says 120 here,
Oh, in the motion, I apologize, Your Honor.
but I mean, do you want to do June?
I think June would be safe. I'm hoping, knock on wood, Your Honor, by then maybe we got a vaccine up and running and you never know, but I would feel better about giving more time so that Ms. Holbert can travel safely, et cetera.
Okay, June 1st, 8th, 15th, 22nd, or 22nd.
I'm sorry, Your Honor. Say that one more time. Give me the dates again.
1st, 8th, 15th, or 22nd.
First,
Let me just, out of an abundance, I'm sure June 1st will work, Your Honor. Let me just make sure. I mean, we have trials. I don't want to.
not the 22nd, if that's possible.
Okay.
Oh, okay, and I was going to say, Your Honor, I do have trial sittings on the 1st and 8th. Now, the likelihood of them going, you never know, but I at this point in time, do not have a trial sitting on the 15th.
15th works.
Okay,
All right, we'll reset it to June 15th, and you guys submitted an order. I'll go ahead and sign it and get it in by tomorrow.
Will
thank
do.
you, Your Honor. May we be
Yes.
excused?
You may be safe out there.
Thank you, Your Honor.
Okay, I think we have our next hearing. Is everyone here that needs to be here?
Are you talking to us, Your Honor? I think
Yeah,
so.
sorry.
That's
You're
okay.
the only case I have, except for Sarah Krajewski. Are you here? Are you here on this case or something else?
I'm here on this case as well.
Okay. Go ahead, Ms. Shigaris.
Well, I think it's Pettit's motion.
I mean, but is everyone here? Ms. Pettit, is everyone here?
Yeah. That's right.
Is here, Your Honor.
Okay, let's do this. We'll go on the record. Go on the record on cause number DC 208643, Hume versus 5-Star Global. Oh wait, Mr. Reimer's not here yet.
Oh, that's right.
We are missing somebody then.
Here he is, I see him.
All right, let's try again. Let's go to the record on cause number DC 208643, Mark Hume versus 5-Star Global. Counsel, make your appearances.
Good afternoon, Your Honor. Julie Pettit and David Urtiago on behalf of the plaintiffs.
Leslie Shigaris and Jessica Lopez on behalf of the FSG defendants.
Nancy on behalf of Southfield.
Good afternoon, Your Honor. Ben Reamer on behalf of Michael Knoll and Mid-Market Place PBC LLC.
Okay, I believe this is Ms. Pettit's motion. And Mr. Buchanan, are you there?
Your Honor, this is Cassie Hines. Mr. Buchanan is present. He had to call into another hearing in probate court. So he is, for purposes of this hearing, attending via Zoom by, he's just muted with his camera off, but is here in case he's needed.
Okay. Ms. Pettit?
Thank you. If Your Honor will allow, Mr. Urtiago is actually going to argue on behalf of the plaintiffs.
Mr. Urtiago?
Thank you, Your Honor. And is it possible that I can use the share screen function? Is that unlocked?
Yeah, let me just do that real quick. There you go.
Thank you. The reason why I want to share my screen is that I actually want to start with the opposing side's response. because I think it may be illuminating exactly why we're here today. This is Exhibit 1 to the response, and it's an email exchange between Ms. Pettit and Ms. Chigueras, as well as other counsel for the parties. And if we look at the first email, it's on October 21st, 2020 by Ms. Chigueras, and it's to Ms. Pettit as well as counsel for mid-market. And it says, Ben and Julie, I left a message for both of you. Under the TRAP, before we can ask the Court of Appeals to stay an interlocutory order, we have to ask the court to set a supersedis bond. We are filing that motion this morning. Given the timing, we will be asking for an emergency hearing so we can set it on Friday. At the same time, the court has scheduled a hearing to finalize the receivership order. Based on the case law and plaintiffs' arguments regarding their own bond, we intend to ask for the supersedis bond to be set at that same amount of $10,000. And then if we look at the response, of course, the end of that email was simply asking to conference regarding the amount of the bond. And the response from Ms. Pettit on October 21st was, sorry, I had an appellate argument this morning, but I'm back to reality now. Yes, $10,000 is just fine. And then, of course, the remainder of the email is regarding an administrative issue, that needed to be resolved for the final receivership order. So based off of this, the motion was ultimately, the motion for the receivership bond, the supersedis bond was ultimately approved as unopposed by Your Honor. And it's now the position of FSG that this is agreed upon bond, with the bond amount was, of course, agreed. But because there was an agreement that essentially this was a trap that Ms. Pettit had essentially fallen into, that by agreeing to the $10,000 figure, we had essentially agreed to supersede and stay the enforcement of the receivership order pending appeal. Of course, that's not what happened. However, FSG parties have objected to the enforcement of the receivership order to Mr. Buchanan based off of posting a supersedis bond, and Mr. Buchanan cannot move forward until there's at least some clarity in the record of exactly what had occurred here, even though I think all parties are clear on exactly what Your Honor's order was, which was that Your Honor was not staying the enforcement of the receivership order pending an appeal, that to the extent that the FSG parties wanted to stay the enforcement of the appeal.
Let me tell you my general view on this type of thing, because this happens, occasionally, not usually in this situation, but in other situations. I very rarely stay my orders unless I have to, unless it's required, obviously. I very rarely stay my orders if the Court of Appeals, because of some type of action that the Court of Appeals would want to take. And so I don't usually, in fact, I don't know that I've ever stayed unless I had to, ever stayed an order. I usually take the position that the Court of Appeals wants to stay my order, they can, but if it's discretionary, then I don't usually do that. Is this discretionary or not, or do I have to stay it?
Your Honor, it is discretionary, and since I have the share screen, I'm just going to show you the rules that both sides are arguing about. This is Texas Rule of Appellate Procedure 24.2. Specifically, it's A3, because that has to deal with judgments which are not involving money judgments or property. And it starts down here, but the bulk of it is up here on the right. And it says, for something other than money or an interest in property, the trial court must set the amount and type of security that the judgment debtor must post, which of course was why we agreed to the $10,000, because that's a must. But then it goes on and it says, the security must adequately protect the judgment creditor against loss or damage that the appeal might cause, but the trial court may decline to permit the judgment to be superseded if the judgment creditor posts security ordered by the trial court in an amount and the type that will secure the judgment debtor against any loss or damage caused by the relief granted by the judgment creditor. Your Honor has already set that amount. That's explicitly in the receivership order. Of course, it's pursuant to the Texas Rule of Civil Procedure requiring that receivership bond in the amount of $10,000. I don't have the exact rule in front of me, but it's in the 600s. So Your Honor has already determined that an amount that would adequately protect the other side was $10,000, and that amount had already been posted. So it's certainly our contention that under the Texas Rules of Appellate Procedure 24.2 A3, Your Honor has stayed the enforcement, or excuse me, has adequately protected the other side to allow for the enforcement of this judgment pending appeal. The confusion, though, however, is the rule that we're relying upon to show the fact that FSG has been adequately protected is in the rule of civil procedure, as I mentioned, regarding specifically receivership bonds. But the rule that the other side is pointing to, of course, is the rule we just looked at, which is the Texas rule of appellate procedure. And I don't want to overstep my understanding of the other side's reasoning, but it's sort of my understanding looking at their response that they're contending essentially that that bond that the court has already ordered would not qualify under Rule 24.2 A3, and that since Your Honor has already signed the receivership order, it's too little, too late. In fact, I think that the quote from the opposing brief is one, too little, too late, and two, the ship has sailed. Essentially, they're claiming this is an issue of timing that Your Honor may have intended to allow for the receivership order to be enforced. However, because essentially Ms. Pettit fell into a trap unknowingly by apparently agreeing to the amount of the supersedis bond, and they in fact did post that supersedis bond.
I have to admit, I'm not exactly following that, and maybe Ms. Shigaris can illuminate it. Are you saying that because Ms. Pettit agreed to a bond that was lower than the amount that would protect Ms. Shigaris's client, even though Ms. Shigaris suggested that amount, that therefore I must stay the execution of my order? Is that what you're saying? Or am I missing this?
Are you asking that to me, Judge,
or either? Is that what you're trying to say, Mr. Artiago?
And Your Honor, what I was trying to say is a little slightly different, which is simply my understanding of the other side's position is that it's a matter of timing, meaning that Your Honor has the ability to prevent essentially the judgment from being superseded, that Your Honor can allow and has the discretion to allow for the order to go into effect pending the interlocutory appeal. However, they're claiming that Your Honor doesn't have that ability currently as we sit here today because Your Honor has already signed the order appointing a receiver. However, that's why I pointed Your Honor to the fact that Your Honor has already set the bond. Of course, the bond was pursuant to a different rule of civil procedure, this one specifically dealing with receivers. But regardless, the bond has already been set. It's the same bond, same purpose, same reasons for the bond, and the bond has been posted. So under the explicit language of Texas Rules of Appellate Procedure 24.2 A3, FSG has been adequately protected. And the order can go into force and effect. And there was no waiver simply because Ms. Pettit agreed to the amount of the supersedis bond, the amount, of course, the other side was entitled to have issued, even though they are not entitled to the stay of the enforcement of that order pending an appeal.
Okay. Ms. Shigaris?
Yes, Your Honor. I think there's several things to unpack here, but if Mr. Artiago could stop screen sharing.
No, no, don't do that. I want to read this again.
Okay.
Okay, go ahead.
Only because I have a PowerPoint that has these rules set side by side, which was helpful to me walking through how the different rules work. And that's what I wanted to put up. If
that's fine.
I'll stop sharing then.
Okay. First, I have to address something that was just said, that for some reason, Mr. Artiago and I guess Ms. Pettit believe that I set a trap for Ms. Pettit. And I just want to be really clear. After I sent that email to Ms. Pettit and before she responded, which by the way, I left her a voicemail and I asked her to call me, but before she responded, we filed our motion along with our case law, clearly setting out what we were asking for from the court. So this idea that I sent some email, she agreed to a bond, and then all of a sudden I set some trap for her. I'm very bothered that that's being represented to the court, but I'm just going to move on to.
I have to understand. I have to admit, I'm not exactly sure I follow what the trap was, like how you trapped the other side. Other than I gave my understanding of apparently that was incorrect.
Yeah. So I'll walk you through, and this I think will help Your Honor see what we were moving for, what they've now asked, and where the right decision comes out on who has authority to look at this issue now. So our position is that at this point, what the relief that the plaintiffs are asking for, the jurisdiction now is properly in the Court of Appeals. And the reason for that is when we, as
let me ask you this, and I may be missing the point here because this was originally set the other day and then you canceled and you rescheduled to today. And I've read it, but I don't know that I fully get what we're doing here. Are you taking the position that I am mandated to stay the receivership order based on the posting the supersedious bond?
Slightly, yes. It's our position that at the time we asked for the court to determine an amount of supersedious bond, the court had two options. The court could either set an amount of supersedious bond, and then once we posted it, that's it. And I'm going to show you the Court of Appeals opinion on a receivership order that looked exactly at these rules, Judge, so you can see how this plays out. But what we did is there's two rules of appellate procedure at play. The first one is Rule 29, and that's what we moved for relief under. 29.1 says, of course, an interlocutory order is not suspended unless it has been suspended under 29.2.
Under 29.2, it says the trial court may permit an order granted interlocutory relief to be suspended pending an appeal from that order.
Exactly.
If the trial court refuses to permit the appellant to supersede the order, the appellant may move the appellate court to review that decision for abuse of discretion.
Right. So then what you look at, and I'm going to give you two more pieces and I'm going to explain how we got here. 29.3 says if the appellate court, so this is just the general, if I'm on an interlocutory appeal, I cannot go to the Court of Appeals to ask for any temporary relief if I should have asked for a supersedious bond first. So if you remember when we had the hearing on the receivership order, and I said, Judge, I went back and looked at the appellate rules, and there's an Austin Court of Appeals that just came out this year on receivership orders. And I'm going to come back to the rules, but I just want to show you this case because this is exactly what played out in the Austin Court of Appeals in 2020. The trial court issued a receivership order. The defendants appealed, and they asked the Court of Appeals to stay the receivership order during the pendency of the appeal. That's what I thought would be the likely course of action. That's what they did. The Court of Appeals said, no, you can't come to us and ask for a stay until you first go back to the trial court and ask for a determination on a supersedious bond. And
I've already done that, I guess.
And that
was agreed to.
That's what we came to you. That's what we had filed our motion, and that's what was agreed to.
Okay.
But let's say you hadn't agreed to that, because I just want to make sure, like if I'm setting a trap, I want to make sure what the outcome would have been if we hadn't done it by agreement. In that case, when it went back to the trial court refused for the receivership order to be superseded. And they permitted plaintiff to post this counter supersedious bond, which is the exact relief that the plaintiffs are asking for you to do here. Don't let it be superseded and allow us as the plaintiffs to post a bond that would protect the other side on appeal. Went back up on appeal. And
okay, I have to admit, I've never heard of a counter supersedious bond, so this is a little new to me. Why doesn't the receivership bond, the bond on the receivership order, protect the defendants? Why do you need another bond, a counter supersedious bond? I'm not saying you're wrong, I just don't know.
I think it's different because the receivership bond, it could be the same, but I think it's different because under the trap rules, you're looking at what would protect the appellant during the course of the appeal. So if I'm not able to stay this during the course of the appeal, is there some harm by virtue of me not being able to stay, which is the general rule, right? Generally speaking, judgment debtors, whether on an interlocutory appeal or otherwise, are generally allowed to have that order suspended while they're appealing it, because otherwise, a lot of times, if you didn't do that, then the appeal would be rendered moot because all of a sudden the order has been in effect. Does that make sense? And so what you're looking on an appeal is the appellant damage or detriment that could happen by not allowing the supersedious to play out, which is the normal course. So in that case, like I said, let's pretend that Your Honor never signed the supersedious bond order allowing the defendants to post that. In that case, the trial court did exactly what the plaintiffs are asking Your Honor to do. And when it went back up, the Court of Appeals held that was an abuse of discretion to refuse to allow the defendants to supersede the receivership order, to not allow them to supersede it during appeal. So it is a discretionary, it's not that you have to, but under this 2020 case out of Austin Court of Appeals on a receivership order, the exact thing that they're asking you to do was reversed.
So I think you hit on something that is I'm trying to figure out, which is I have discretion on whether or not to stay this order, correct?
You
The
have
Court of Appeals may disagree and say I'm abusing my discretion, but I have discretion to do that, even if you posted a supersedious bond, correct?
I don't think you do at this point, but I think at the time.
Why don't I have it at this point?
Because we've already posted our bond and we've already filed a notice of appeal and the record has already been filed. So I actually think, as you understand, or, Your Honor, if once a matter has gone up to the Court of Appeals, I believe that the Court of Appeals would have discretion over that subject matter. And I think that that's the point we're at.
Okay, but my question is about staying the receivership order.
Right.
Because I've entered, but correct me if I'm wrong, I've already issued the receivership order, correct?
You've already entered the receivership order and you've already entered the order of permitting defendants to post a supersedious bond.
And so so right now the receivership order is in place. No court has stayed it, correct?
The posting of the supersedious bond pursuant to your order has stated, yes.
It is automatically stated because it seemed like I had discretion according to that. What is it, 92.3?
That's what we're arguing here about, Your Honor.
You had discretion, but you granted the supersedious bond. You granted our motion to allow us to post a supersedious bond. At that time, the court had two options. And part of that is because, part of the reason we're here is because it sounds like maybe Ms. Pettit didn't understand what she was agreeing to. I didn't know that.
Oh, I was very clear on what I was agreeing to, and I've got an email that's very clear on that as well.
What I'm saying is they had the whole substance of our motion. We came to the hearing, and what we were asking for is, Judge, we want you to set an amount for a supersedious bond. Once you have set that amount, then posting of that bond is automatic. That posting supersedes the underlying order automatically. And I don't think there's that part is not in dispute. The question is, at the time that you granted that, if the plaintiffs had wanted the relief they're now seeking, what they should have said is, Judge, we don't agree to any amount of a bond. We don't believe that the order should be superseded. Instead, we want you under this other rule, right here, 24.2, to decline to allow the defendants to supersede the judgment. And in declining to allow the defendants to supersede the judgment, we, as the winners, the plaintiffs, will need to post an adequate bond in order to protect the defendants on appeal. That didn't happen. And so if they wanted the relief they're asking for now, that should have happened at the time we asked for the relief. If they didn't want to agree to it, I mean, I was prepared to argue it. So I'm not sure how we got so far off, but look, if it's a misunderstanding, I understand that. But what they should have done is, instead of agreeing to the supersedious bond, they should have said, Judge, we want you to decline the judgment from being able to be superseded. Had they done that, the Court of Appeals in Austin has already looked through this exact issue and said, on this kind of case, that would be an abuse of discretion. I understand that might be a different scenario, and the reason they've said that is important, because if you look at Mangas versus Transmission, once a trial court grants the appellate the right to supersede the bond, it cannot thereafter render meaningless the right to supersede the judgment. By permitting appellee as an afterthought to file a bond.
This isn't a judgment, this is an interlocutory order, isn't it?
It is, the reason these use judgment, Your Honor, is because if you look back on sorry, I'm skipping so much over, but if you look at 29.
So I guess my question is, why isn't this controlled by 29.2 that says the trial court may permit an order granting interlocutory leave to be superseded pending appeal from the order. If the trial court refuses to permit the appellant to supersede the order, the appellant may move the appellate court. Oh, so I guess the argument here is that because I allowed the supersedious to occur, then 29.2 doesn't apply.
Well, it's two things. One, I think because you allowed it, it wouldn't apply. But more to your direct question, both 29.2 and 29.3 incorporate Rule 24, right? So if you allow us to supersede it, then we look at the rules under Rule 24. And if you look at 29.3, right, which says we can't go to the trial court, and we can't go to the appellate court and ask for a stay there if our rights would have been adequately protected by seeking some kind of supersedious under Rule 24. So when you go to Rule 24, you can't just refuse to allow us to have a supersedious bond. You would have to allow the plaintiffs, or require, not allow, you would have to require the plaintiffs to post an additional bond that would protect us against the loss. And that's not what happened because you've already signed the order. So at this point, they can go to the trial court to review the decisions. And if you look under 24.4, which is the same rule they're citing to, Your Honor, the appellate court can review the sufficiency or excessiveness of the bond, the determination of whether to permit or suspend the enforcement, the trial court's exercise of its discretion under 24.3A. So we agree.
Ms. Hines, is Mr. Buchanan, can you see if he's available?
Yes, give me just a second.
Your Honor, may I speak briefly? I'm trying to bite my tongue, but may I be heard briefly as well?
Okay.
I'm sorry.
Yeah, you may, but I want to hear from Mr. Buchanan when he's available.
Certainly.
Texting, he's on his cell phone at the moment, so give me just a minute, please, Your Honor.
Okay, go ahead, Ms. Pettit, while we're waiting.
Sure. So just by way of reminder, in the very initial hearing where Your Honor did grant the limited receivership, Ms. Shigaris asked at that point if Your Honor would stay the enforcement pending appeal. Your Honor was very clear. I don't have the transcript in front of me, but Mr. Urtiago and I spoke about it this morning, and Mr. Buchanan and I also spoke about it this morning. Your Honor was very clear that you were not going to stay the enforcement of the receivership order pending appeal. May I share my screen briefly?
Sure. Let me see. We have to, do we need to, okay, go ahead.
Judge, if I may just interject for a moment. I'm here. Let
me ask you a quick question, Mr. Buchanan, and you can say if there's something else you wanted to say, you can.
I was just going to say, Judge, that I was on a hearing with Judge Thompson and it was set for the same time.
That's okay. That's okay. So no problem. I just had a question for you. So it seems a little murky to me on whether or not I'm required to stay my own order or if this receivership can go forward. And so my inclination is, my intention clearly was to not stay this order and let the Court of Appeals do it, but the supersedious issue may, cause a wrinkle in that. Do you feel that you can go forward with the receivership, assuming that I do nothing at this point? Do you feel you can go forward with it, or do you feel that that would be in violation of the law because this has been superseded?
So, Judge, if I may, and not to parse your question.
Okay.
But just, can you hear me okay, Judge?
Yeah.
So not to parse your question, but just to make sure I understand your question. So it is best, my recollection, it's pretty clear that at the time you signed or entered or ruled rather on the receivership, and there was a request to stay that by the other side, the defendant. My recollection is says you need to go see the Court of Appeals about that.
I said that, yes.
Okay, so first step. So if it's a step, So subsequent to that, upon the entry of the actual receivership order, I believe the same morning, Cassie wasn't with me that day to help me remember, you did enter an order that set the amount, not to parse at all and not to argue aside, that set the amount of a supersedes bond. In the court, the parties are grappling with, to quote Ms. Shigaris, has the ship sailed, or to quote me, is the horse already out of the barn? So, so the question is I think if you do nothing, I'm a little uncomfortable with proceeding under the receivership. I think there needs to be, at a minimum, if the receivership is to go forward, some clarification of the court's order that, quote unquote, set the supersedes bond. There's a reason why I haven't posted my bond, Judge, because I wanted the court to hear the parties out and sort these issues out going forward. Judge, if I in any way, shape, or form answer your question.
Yes, exactly. You answered it exactly you answered exactly what I wanted to know, which is, do you feel comfortable going forward if I do nothing?
What we don't want to do is
no, you don't want to go forward with the receivership if it's been properly superseded and put egg on your face and my face if that happens.
Or expend a lot of time and energy and money for all the parties. I mean, this is a very, very unique issue. Frankly, I've never seen this before. And so I think that if the court, choose your words carefully, Kevin, because life is always about the next case. I think if the court has some concern about the effect of its order regarding the supersedes bond, I think you could take it back. That's the wrong choice of words. I think you could clarify that to where the only purpose of that was to set an amount in the event that the appellant was successful upon appeal. Now I'm starting to get in the weeds, Judge. But
yeah,
right. I'm getting in the weeds.
That kind of raises another question: is it possible for me to vacate this? I mean, my very clear intention was that I wanted this receivership to go forward. I never intended to stay it, and that was my intention, and that is still my intention. If I have any discretion in this matter, that's what I want to do.
So,
I'm willing to risk a ruling from the Court of Appeals saying I abused my discretion. I do not want to blatantly violate the law in doing that. And I do not want to put Mr. Buchanan in a situation where he expends a great deal of money and effort to pursue a receivership that the Court of Appeals may say, look, you don't have the authority to do. And so that's my quandary at this point. And so I guess one question I have to Ms. Pettit is, can I vacate that order, or is that ship sailed?
Your Honor, the proposed order that that we have drafted, I believe, is essentially what Your Honor is contemplating with, and I can have Mr. Artiago maybe share screen on that because I know he has put one together that I think might do that. If I can take a step back just briefly to be clear on and I'm going to share screen if that's okay.
Sure.
Let's see if I can get it up. Okay, so after the hearing, you can see I followed up at 10:04 and said, Leslie, to be clear, I'm unopposed to the bond amount, but we're not in agreement on the stay. Judge Hoffman already denied the stay and said you would need to seek that from the Court of Appeals. Am I missing something? And at the time, I thought Ms. Shigaris and I were in agreement because she said the only thing for Judge Hoffman to decide is a bond amount, which is what our understanding was. So I think the trap that I fell into is that by trying to not argue about everything and agree to a bond amount, I've now somehow voluntarily consented to a stay, which was clearly against Your Honor's intent and certainly against my intent. It would be preposterous for me to seek a receivership and then voluntarily agree to a stay pending appeal. And I thought we had been perfectly clear about that. With that, if I'm hoping Mr. Urtiaga can share his screen on the proposed order, or at least share the terms of it that I think would accomplish what Your Honor is seeking.
And you
just make sure, because look, now this is, I mean, obviously Julie and I are friends, and so I say in this email, the rest of the language flows from the rules of appellate procedure, and those rules, how they work, were laid out in the motion that had been on file for 3 days. So
Sure.
I just want to be very clear. Look, if I wasn't clear with Ms. Pettit, then, you know, that's something she and I need to work with. But to suggest that all of a sudden I've laid some trap or said something that wasn't forthcoming, I'm really bothered by that accusation.
Your Honor.
I guess.
Go ahead.
I'm not trying to cast aspersions. I think you're both great lawyers. I kind of want to order you guys to go to brunch and mimosas or something to try to work this out, because I'd hate to see this damage your friendship, because this may have just been a miscommunication. But it does kind of bother me that it was very, very clear that I did not want to stay this. And so if by signing an agreed order, I somehow did something that I never intended, I would like to be able to reverse that. That was my fault as much as anyone else's. I take responsibility for this, that I didn't figure that out. I should have figured that out if that was what the legal result of this is. I don't want to put Mr. Buchanan, most importantly, in a situation where he's acting on an order that should be stayed. And he seems to be concerned about that. And I respect Mr. Buchanan a great deal, as I respect the other attorneys here. So let me see the proposed order.
Your Honor, I was actually going to say I was caught a little flat-footed. I had not crafted the proposed order because I did not know what Your Honor would be ruling, because this is an unusual situation. What we would ask the court to do is that we had styled the motion as to appoint a counter supersedis bond. And just to be clear, the laws and the rules and how we're seeking to apply them to this fact pattern are highly unusual. In fact, the only case that really addresses some of it is the Austin Court of Appeals case that has been referred to by Ms. Shigaris, understandably, because it does address a lot of these specific concerns. And what had happened, go ahead.
Okay. Let me ask a question here. So I haven't dealt with this that much, but it's always been my understanding that I can modify a supersedious bond. I don't remember if that is on the Court of Appeals has to order me to do that, but I know there's a process for that. Is there also a process to vacate a supersedious bond? Is that anywhere in the rules?
Your Honor, I would suggest that to answer to explicitly as possible, there's nothing specifically in the rules that say Your Honor can vacate a supersedis bond. However, Your Honor is correct that you can modify that bond, and to the extent that you modify, that is of course a rejection of the original bond amount. So I don't want to necessarily be splitting hairs on vocabulary. Your Honor can change a supersedis bond order. However, I would not even suggest to the court that that's necessary. What we would be asking for is simply an order that clarifies the effect of creating a supersedis bond amount, and also clarifying the amount of a counter supersedis bond. Because in the Austin Court of Appeals case that both parties have been referring to, that's exactly what happened. The trial court set both a bond amount for a supersedis bond as well as a counter supersedis bond amount. And the issue on appeal on that case was whether or not that amount, excuse me, this counter supersedis bond amount was reasonable. The Austin Court of Appeals found it was unreasonable, and of course vacated that order. So
can I see that opinion? Can you share screen that?
Sure.
Everybody seems to see seems to agree that this is kind of the case I need to look at.
It is certainly the closest one. And Your Honor, I don't want to be too hyper technical, because while I do think that this is the case that is probably the most on point that Your Honor should be looking at for appellate purpose, to the extent that we have to be going up on appeal to make these arguments, we are actually not conceding that this is controlling case law. It's the only case of its type from any court of appeals.
Let me just look at it. I
understood.
Let me just look at it. I know that I'm not bound by the Austin Court of Appeals.
And Julie, can you stop sharing your screen?
Yes.
Who's bringing this up?
I'm going to be bringing it up, Your Honor. I just had it downloaded. I just had it on Westlaw. Okay, can you see the case now, Your Honor?
I can now. Let me see. Can you
Let me
go to wherever?
Sure. So starting with the analysis, you can see them start talking about some of these rules.
Okay, go down. Go down. Go down. So it does say you can do a counter supersedeas. It just has to be sufficient.
That is correct, Your Honor, and that's why we're asking, Your Honor, in a forthcoming order to simply set that amount at the $10,000 Your Honor has already determined to be sufficient to protect the other side's interest. That way, at least, we would have clarity in the record that we have in fact prevented the suspension of this order pending appeal, at least pursuant to this rules of appellate procedure, which may or may not be applicable.
Mr. Buchanan, how do you feel about that?
Judge, can you hear me okay?
Yeah.
Judge, I'm really in a tough spot here. However, I think that probably more than likely cures the problem. And I'm going to have to take Ms. Shigaris out for whiskey or mimosas after I said that. But I think this is tough, Judge. Everybody on these screens know each other. And that's my best reading of this case, is that, you know, again, I'd never seen this before, that the filing of the counter supersedeas bond would let the receivership go forward. As an aside, I don't know if it's a relevant aside or not, but one of the interesting things about procedurally where the receivership is at this juncture is that, as the court, all the parties know, this is, under the receivership statute, chapter 64, the applicant and the receiver both have to file bonds. And to quote one of your colleagues, former colleagues, the filing of both those bonds is jurisdictional. Without a receivership bond having been filed, and I didn't file one because I wanted this sorted out, there really isn't a live operative receivership order until the bonds are filed. So I don't know if that helps the court's reasoning or not, but back to the court's question, this case seems to me to support the argument that the filing of a counter supersedeas bond would solve the problem. It doesn't require the court to vacate its earlier order. It's I think an additional order.
So, okay, that's what I agree with you. I'm glad we're on the same page, but I also, they can reverse me, but I've definitely been reversed before, but not as much lately though. It's kind of a nice, but
yes, sir.
I'm not sure why that is, what's changed. It's a mystery, but maybe I'm just getting to be a better judge. I'm sure that's what it is. I don't know where I was going with this, other than I'd like to go ahead and try this, but I guess the issue then becomes, is 10,000 an adequate? Ms. Shigaris, are you contesting that $10,000 would be an adequate bond in this case, an adequate counter supersedious bond?
We would contest that, Your Honor. I just want to address two things. One, and I don't know if we can.
Oh, I'm sorry.
Pace real fast. Just Mr. Artiago, could you scroll up just slightly on that page? I just want to make sure we're.
Sure. Tell me when to stop.
Yeah, right there. It's perfect.
Okay.
So, Your Honor, I know you just read the case on the screen, but what the Court of Appeals said was this counter supersedious in that case was not sufficient. But if you look at where it starts, asterisk 3 page, they then said it was abuse of discretion by refusing to allow the appellants to supersede. So even though it's a mechanism, the Court of Appeals said it was abuse of discretion for the trial court to allow for this, quote, counter supersedious bond and not allow the defendants to supersede. I understand that you may wanting to make this decision and let the Court of Appeals determine, but I just want to be very clear that that's the holding right there.
But it says that, in that case, they completely refused to allow them to supersede. There was no bond set at all, correct?
No. So what Mr. Artiago just suggested is exactly what they did in that case. He said, I'm going to decline the right of the the defendants to post a supersedious bond under Rule 24, like they're asking you to do. They set a counter supersedious bond at 10,000. And then in the same order, he said, or in the alternative, we'll set the supersedious bond at 10.5 if defendants are successful on appeal, convincing the appellate court that it should be stayed. So this alternative.
But don't you think that for that part, that's very different than what we have here? They're dealing with all I've ordered in the receivership is basically, Mr. Buchanan, you need to just kind of take a look at this. He has very limited powers. He can't fire people. He can't, sell assets. He can't really do much other than just making sure that the company's not being looted. It's very different than what's happening here. And it doesn't say that you can never do it. It just said in this particular case, it was an abuse of discretion not to do it, right?
I think that's right. So I want to address your bond question directly, and then I want to raise one other case that might be helpful on this point. We would contest that 10,000 is sufficient. In the record, the plaintiffs have not presented any evidence that $10,000 would be sufficient to protect the defendants on appeal. Instead, what you have in the record is sworn affidavit testimony that of the risk of default by the ordering of this receivership order, not just to Southfield, but also to Veritex. You have sworn affidavit about the potential implications to the business, the employees, and investors, just knowing that this business is being placed into receiver. So the only evidence in the record shows the real risk to us that we will experience, even though I understand the lawyers in the room, you, Your Honor, the receiver, understand it's limited. Not all these other parties may interpret it that way. They have no evidence that supports the number of $10,000. That's just what they've thrown out there, and it's not based on any evidence in the record. So that would be a problem. And kind of on a related note, in this case I was going to show you on my slides, but we didn't get there, is NRA Dallas area rapid transit. It's a slightly different case in that it was an injunction, but the injunction was actually over a FOIA request or public information request. And kind of the same thing. They said, well, the order is just limited. It's just getting documents over to the other side. And the Court of Appeals said, yeah, but if you don't allow that to be superseded and the party is forced to go ahead and turn over the documents, then the appeal is mooted because they've already gotten the relief before you get a chance for the appellate court to review it. So I understand that Your Honor's leaning a different direction, but the fact that it's limited in this case, I don't think changes the protection.
No, I don't just, no, I'm just saying what it should be the amount of the bond, not whether or not it can be superseded. Of course, the Court of Appeals, if they come in and say, look, you shouldn't have done this, obviously, that's, my only point is the amount of this would affect the amount of the bond because it would, but.
So in the other case, the court rejected a $100,000 bond and said it should have been based on the percentage of the ownership interest. I agree that I don't think that kind of bond is warranted here because it is a more limited order at this point. But I think it would have to be more in the $100,000 range in order for, I mean, based on the evidence we have in the record that hasn't been disputed, I can't see something less than that adequately protecting the defendants on appeal.
Your Honor, if I may, I was actually switching to just a different rule. And this is Rule 695A and has to deal with bonds and receivership cases. And of course, we've already discussed this rule. And the reason why I bring it up is because Your Honor already set a bond of $10,000 pursuant to Rule 695A. And the rule says that the amount of such bond shall be fixed at a sum sufficient to cover all such probable damages and costs.
Okay,
And
so let me ask this though: is the receivership bond, is the counter supersedious bond necessarily going to be the same amount as the receivership bond, or should those be different numbers?
Your Honor, I would certainly submit to you that it should be the same number. In fact, if necessary, I honestly believe that the supersedious bond, the counter supersedious bond, is the same as the bond in 695A. There just doesn't, I mean, it's almost identical language. It's meant for the same purpose, which is the protection of the other side's interest in the event that this receivership was wrongful. There is no reason why these bonds should ever deviate in their value because they're protecting the same interest. And Your Honor, this is unusual fact pattern, unusual question of law for which I have yet to see hardly any good authority on. Even the Austin Court of Appeals really didn't dig into this issue. But it would seem to me that the bond that's required by 695A is essentially the same bond as the counter supersedious bond, which automatically, go ahead.
Isn't one of the issues on that Austin Court of Appeals case that there wasn't enough evidence that was presented to justify the court's finding on the amount of the bond? And do I really have an evidentiary record here?
Well, so Your Honor, the reason why I was pointing out that there was already an order is that discussion, that record, if you will, has already been developed as a part of the receivership hearing. Your Honor has already determined what amount would be sufficient based off that record to protect the interest of FSG. And so really at this point, we would just be recreating the exact same record for the exact same purpose for the rules that have almost identical language. That's why we would say that the bonds should be the same, and it's based off Your Honor's prior ruling based off that record. Here, we're just relitigating literally the same issue, which is how much should the bond be to protect the other side's interest pending an appeal. And frankly, the fact that we have to pay it again effectively doubles our client's bond after Your Honor already determined it was only $10,000. Now, just to protect ourselves, we're going to have to double it.
I'm not suggesting that 10,000 shouldn't be it. I'm just wondering, do we have an evidentiary record on on setting the amount of this bond? I don't want this to go on appeal and then I get reversed. This would make Judge Hoffman unhappy, to speak in the third person.
Yeah. If
we didn't develop a record on this particular point and I get reversed because we didn't develop a record because we're trying to short circuit this, that would concern me. Don't have it. I don't know that we have an evidentiary record on this. Maybe they are the same, but my read of this is there has to be evidence presented. Unless Ms. Chigueras and Ms. Pettit can reach some kind of agreement, it would seem to kind of be in good faith, since Ms. Pettit agreed to the 10,000, that Ms. Chigueras could agree to the 10,000, and maybe we wouldn't have to go through a whole hearing on this. But but I can't mandate that.
Judge, if I may,
Mm-hmm.
I see these as two different animals, maybe two different pieces. Judge, can you hear me okay?
Yeah.
So a bond for receivership, a Chapter 64 receivership, and I know there's been reference to Rule 695A, and I'm used to dealing with that particular rule over in divorce court when I'm selling houses and ranches. I think is a different animal than how or how much a supersedious bond should be, or a counter supersedious bond. So I think the court's observation
You cut out there.
that there should be some sort of, I think the court's observation, well, first of all, to back up, I think a supersedious bond or a counter supersedious bond is a different animal than a receivership bond in terms of the way or the amount in which it's set. So I do think the court should treat these two things separately, absent an agreement amongst the parties. Because
so you think I should have an evidentiary hearing to be
yes,
safe?
sir.
That's kind of my thinking too.
Right, and I expect somebody's going to ask me, Mr. Buchanan, what's your budget? I mean, because that's part of the way the order is structured, the company's supposed to pay me, just by way of example. And so just for, I don't want to issue preclusion on down the road in my life, but I do think they're two separate things. I think the standard for the setting of a receivership bond is much less, there's less scrutiny.
I agree with you.
Than on a supersedious bond.
Ms. Chigueras, how do you want to proceed?
Now, Ms. Pettit, a whiskey or a mimosa?
Yes, Your Honor, I can't agree to it. We objected to 10,000 in the first instance. The only reason I thought Ms. Pettit was agreeing to it was because that was her argument that $10,000 was sufficient. And so I thought she would have a hard time coming to the court to say, well, it was sufficient to protect them, but not to us. At the time it was set at 10,000, you'll remember, Your Honor, we asked for $1 million bond. I said that maybe, under the circumstances of the more limited, that 25,000 to 50,000 might be sufficient, but I didn't agree to 10,000 being adequate then, and I cannot agree to being adequate now because it
you could agree to 25,000.
I don't think I can agree to anything because we will be seeking relief in the Court of Appeals, and I just can't waive that right. I'm sorry, Your Honor. I do try to agree, but I cannot in the circumstances.
All I'm asking is, can you agree to the amount of an adequate bond, not that you won't appeal it or you won't attempt to say that, that's all I'm asking for, or whether or not this should be stayed or.
Unfortunately, I think the way the rule works, Your Honor, is if I agree that 25,000 adequately protects us, then I think it undercuts the merits of our argument that the whole order should have been superseded and that the counter superseded shouldn't have ever been allowed. I hear what you're saying. I cannot agree. I'm sorry, Judge.
Okay. So this brings up a slightly different procedural issue, which is this wasn't set today. I don't believe, I'm not sure what exactly was set today. Was the setting of the counter supersedious bond set for today?
Yes.
Yes, sir.
Okay. So are you prepared to go forward with an evidentiary hearing on that?
No, Your Honor, but we can certainly, if Your Honor will allow, we would request to continue this hearing until we can have a witness on the record with us.
Okay. When do you want to redo this?
Let's see. Does the court happen to have any time on Friday?
Let me see. Oh, I'm sorry, I'm looking the wrong day. Let me see. Oh my gosh, I have a really busy, wow, that is pretty jam-packed. They said 5 summary judgment motions on Friday morning, as well as a number of other hearings. How long do you think this will take?
If we request 30 minutes, I can promise you we will be as efficient as we can during that time.
Rhonda, why don't you set this for 1:30? Let me just double check my calendar on Friday. Yeah, Friday at 1:30 would work. Does that work for y'all?
We can make that work, Your Honor.
Yes, Your Honor.
Yes, Your Honor.
And just to be clear, we'll be, I assume, live witnesses as opposed to just affidavits or.
What? I haven't done enough of these. Can we do this with affidavits, or do we need to have live witnesses?
I'm certainly willing to do it by affidavit if that's more efficient.
I mean, is that permissible though, or do I have to have an evidentiary hearing on this, like a full evidentiary hearing?
Well, Your Honor, I would suggest that I think some of the COVID orders perhaps grant Your Honor
Oh, that's true.
the authority to hear things by submission that you would not normally be able to.
I don't think that, I'm not aware of a reason why we couldn't proceed by affidavit.
Why don't you do this? This might be a way to kind of heal hurt feelings, or however you want to put it. Maybe Ms. Chigueras and Ms. Pettit, you guys could chat by noon tomorrow and make a decision, maybe do a Rule 11 that you'll proceed by affidavits. If you can't, then let the court know to make sure we have enough time. We have kind of an interesting week. We're going to try to do a remote trial next Tuesday. There's still some technical issues we're trying to work out, and now there's this vaccine that who knows if that's going to, anyway, but probably won't affect our trial next Tuesday. But we actually are doing some pre-trials on Tuesday afternoon or Friday afternoon, but those don't start until 3. So no, we have one at maybe 2 and one at 3. I don't remember what we said, but we don't have a ton of time. So if we're going to have a whole fight and have evidence, I've learned with this group, if you say it's 30 minutes, it's probably going to be at least an hour. So, so let me know if you can agree to affidavits, but if you can, that'd be great and would help the court schedule if that's possible.
Okay, just so I'm clear, assuming the parties agree to affidavits, we'll submit that to you this week.
We'll still have a hearing at Friday at 1:30.
Okay. Okay. Either way, we'll have a hearing on Friday.
But it'd be great if I didn't have to hear testimony. I mean, if I have to, I'll do it. But okay, anything else, guys?
Not from us, Your Honor.
No, Your Honor.
You guys have a great day. Good to see you.
You too. Bye-bye.
Bye-bye. Okay, Mr. 14th, Ms. Alpland.
Yes, sir.
Okay, let me just pull your.
How are you today?
Good. How are you?
I'm doing well. Is William on too?
Yes.
Okay.
Let me just pull my docket up real quick.
Yes, sir.
Is this on the Dean case?
Yes, sir.
Okay. All right, let's, and what exactly is this hearing about?
Well, it was an agreed motion to abate, but late Friday, this is a TP SIGA case. And as you know, in TP SIGA cases, you have to exhaust all other forms of insurance before TP SIGA will pay. And we were going to abate the case while the Dean's underinsured was being looked at. And late last week, they decided that they were going to pay. So therefore, Mr. Forsythe's office called me and said, okay, we're going to be non-suiting it as soon as they we get all the settlement documents in. So we don't actually need the motion to abate, but we have a trial setting on 11/17 that we're not going to be there. I mean, we're not going to need it.
So let me make sure you said a few things there. I just want to make sure that we understand that I'm on the same page as you guys.
Yes, sir.
There was a UM policy that ended up paying the full amount of the damages in this case, so there's no need to pursue the bankrupt insurer.
Correct.
Is that right, Mr. Fortieth? You're muted, sir.
Probably I need to be muted, Your Honor. That's correct. There was a settlement reached on all parties. We just need time to get the money in. That's all there is to it. That's it was filed as a minor. He's now an adult. So it's almost like we need to be put on the
dismissal docket.
Dismissal docket for 30, 45 days to see if we get that in, because this is going to be over with.
Okay, that sounds great. Would December 14th give you enough time, or December 8th? Oh no, you have December 14th or December 28th are your choices.
Let's do the 28th. Just in these COVID times, things are just a little weird.
Does that work with you, Ms. Altman?
That's wonderful. Will you take it off the trial docket on the 17th of November?
We'll take it off the trial docket. We'll put down you guys have announced settled, and we will need everything if possible before December 28th. If not, but are you guys both in town on December 28th though?
Somebody will be here with our office.
And
I have no plans.
I will file a formal motion to retain if there is some issue. I do not anticipate it at all.
Well, just one thing, Mr. Fortieth, that I know, even if you file a motion to retain, you'd still have to be there, but you can do it by Zoom. So even if you're on vacation, you could.
I think in fact, I know I think I'm manning the fort as the lawyer after Christmas, so I think it's me. So the answer is I'll be ready.
Okay. So December 28th, we'll put it on the DWAP docket and hopefully get everything done. I'm glad you worked it all out. It was great to see you guys.
Great to see you. Thank you, Judge.
Thank you. You guys have a good day. Glad it worked out.
Thank you. Bye-bye.
Okay, we finally have a break. Let me chat with the interns real quick. Let me see. We have quite a few hearings still coming up, but let me chat with you two real quick. Julian, can you hear me okay?
I can.
All right, so you're nearing the end of your internship as Andrea, and I just wanted to see, is there anything else that part of this is networking, although it's a little bit harder during COVID. Is there anything else, anything I can do to help you guys out before your internship ends?
No, but I just wanted to, not at this time, although I'm sure your input will be very, very valuable when post-grad clerkships come around in the next few months.
Did you need a letter of recommendation or something?
I may request one if you would be willing to write one.
Yeah, that'd be fine.
I appreciate it. Thank you.
Andrea, you there?
I mean, I'm going to keep in touch with you probably on LinkedIn or something. So I'll be around. So if I need help, I will reach out. Don't worry about that one. Okay.
So
I will reach out if I need help. Great.
And we have the lunch with Tu. I really think you'll like her. You guys are very similar personalities. What I was going to mention, Andrea, so usually you can come in on Wednesdays. What's your class schedule on Wednesday?
So I have my 8 a.m. until 9:30, and then I have a meeting for like an hour. I think it's from 1 to 2, but I could leave and come back. Well, 1 to 2 is lunch, kind of. So.
What is 1 to 2 what is that? Is that a Zoom meeting or an in-person meeting?
Yeah, it's an appointment that I have.
An appointment,
So
like you're
it's
going
an hour.
to
It's Zoom though.
It's Zoom. The reason I'm saying this is that with these trial settings coming up, there's going to be, I believe, a mock voir dire that we're going to do, and it would be helpful to have some interns help with that on Wednesday. And so, and it would be nice if you could actually come into the courthouse for that, if you're available.
What time?
On Wednesday. I don't know the time yet. Julian, do you have open? You usually don't come in on Wednesdays, but do you have openings on Wednesday?
Off the record, I could probably skip class on Wednesday because we're doing presentations and I don't need to be there to listen to the presentation. But
what time is your class?
It's 10:30 to 11:20.
Let me do this. Once I find out when the mock voir dire is, I'll email you. I don't want you to skip class for this, but
I was hoping he'd say I could.
Yeah, I mean, you can. I don't think you should. But this mock voir dire will probably only be an hour or two. It would be nice to have somebody in the courthouse, physically in the courthouse, because you're going to need something to do that. But so maybe, Julian, I'll let you know when the mock voir dire is going to be. And then Andrea, if you could just come to the courthouse when you can. And then if you need to do a Zoom call or whatever you can. How does that work?
Okay, so can you still just give the time? So just like, should I come right after my 8 a.m.?
It's up to you.
Like, I don't know how long the thing runs for. That's why. I don't want to be super early and super like ready, and then I show up and I'm too early or I missed it. So
I don't know yet. We haven't set the mock voir dire, but so let me tell you kind of what's going on. So we're doing our first ever virtual voir dire next week and virtual trial, potentially. You saw the hearings on this. And so we are going to try to go forward with that. And so the IT department and the bailiffs have asked that we do a mock voir dire so that they kind of understand what we're doing. And so it would be helpful to have you guys at least available, because we may have you serve as jurors and we may have you serve as, I may need some help actually in the courtroom. I don't know exactly how this is going to work, but IT hasn't let me know what time on Wednesday this is going to be. So I don't know, but I'm planning on being at the courthouse all Wednesday preparing for trials, because this is something we've never done before. So I'll be there all day. I just don't know what time the mock voir dire is.
okay, well, as long as you're there and I'm not confusingly walking around the courthouse very lost, then everything's gonna be fine.
But do you want to, is your meeting at 8 in person or on Zoom?
It's over Zoom. The 8 a.m. is a class, so that's from 8 to 9:30 over Zoom.
It's up to you. I can check with Nancy if you want to come in and do that Zoom call from, I'm just worried that if you do your class and then you come in afterwards that you may, I'm guessing this will probably be at 10. I don't know that. It could be at 9:30. It's still up in the air, but it would be best if you were actually here at the courthouse in case we need you, is my point.
Yeah, I don't want to walk in and y'all be mid something and y'all try to cram me in there. I just want to make it more convenient for y'all.
So what, do you want me to check? Let me check with Nancy to see what time she's going to be in on Wednesday.
Okay, sounds great. Just let me know and I will be there. I'm actually really excited. I actually wanted to observe this because I mean, I know I was in a few of the planning sessions about remote jury. So I'm like, I want to observe it. I want to see it play out, because obviously it's one thing to talk about it, but to see it happen and executed, I'm excited.
I'm excited, a little nervous. I'm texting Nancy.
Judge,
Yeah.
I'll be
Oh,
here
Nancy,
by
you're
6
there. Why am I texting you? I forgot you were
I
there.
don't know. I've been sitting here all day. I'll be here by 6:45 in the morning.
Did you hear that, Andrea? So would you mind letting Andrea in? What time do you want to get to the courthouse? If you get there before your class?
I could probably get there at like 7:45.
Okay, I'll have the front door to the courtroom open.
And I'll.
Okay, perfect. Thank you so much.
Nancy, have you heard at all what time we're doing this mock voir dire? Has anyone talked to you about it?
No, sir. They just said that if it could be after afternoon, that it would be better for the guys because some of them have court that morning and more of them will be free the afternoon.
So we're trying to do. Let me see if they could do the afternoon.
I think IT has to coordinate with you too, don't they?
Right. Yeah, that's the main thing. As I'm going to check with Richard.
Judge, you're still on YouTube.
Oh, oops.